Hello students, warm welcome to the teaching and learning process. I am Divya Gautam, Assistant Professor, Department of Mass Communication, Patna Women's College. Today's topic of discussion is media trial versus freedom of expression. I would like to start this lecture with the saying of Pandit Jawaharlal Nehru. He said, "I would rather have a completely free press with all the dangers involved in the wrong use of that freedom than a suppressed or regulated press." Recently, former Chief Justice of India V. Ramana said that the media is running Kangaroo Courts in India. In this lecture, we will understand Kangaroo Court, media trial and different aspects of it. Let's understand media trial. The term media trial means exercise of media in an unregulated and unrestricted way to use and publish information about any particular event, especially criminal cases. Trial by media is the recently coined term and is used to denote a facet of media activism. It means the impact of television and newspaper coverage on a person's reputation by creating a widespread perception of guilt regardless of any verdict in a court of law. One prominent example of media trial is the O.J. Simpson murder trial in 1994. The case received extensive media coverage with news outlet providing 24-hour coverage of the proceeding. The media highlighted controversial aspects of the case such as Simpson's celebrity status, race relations and police misconduct. The media's coverage influenced public opinion and many people formed strong opinions about Simpson's guilt or innocence before the trial concluded. In the aftermath of trial, the media's coverage of the case was heavily criticized. Some commentators argued that the media had sensationalized the case and contributed to the public's confusion about the facts. Others argued that the media coverage was biased, particularly in how it portrayed the defendant and the police. The O.J. Simpson case is just one example of how media trial can impact the justice system. The intense media coverage can sway public opinion, influence jurors, and create a bias that may impact the outcome of the trial. This highlights the need of responsible journalism, ethical reporting, and balanced coverage of legal cases to ensure a fair trial and the proper administration of the justice. Media trial become increasingly common in India too, with journalists and news organizations often playing an active role in shaping public opinion and influencing the outcome of the criminal cases. This trend reached its peak in the late 2000s and the early 2010 when high-profile cases such as the Arushi Talwar murder case and the Nirbhaya gang rape case received extensive media coverage, with reporters and the news organizations taking a prominent role in shaping the public discourse around these cases. In recent years, there has been a growing awareness of the danger of media trial, with several courts in India taking a strong stance against the practice. In the 2017, the Supreme Court of India issued guidelines for media coverage of criminal cases, which included restrictions on the publication of information that could prejudice the trial, as well as a requirement for journalists to report accurately and responsibly. Despite these guidelines, media trial continued to be a controversial issue in India, with many people arguing that media has a responsibility to report on criminal cases in the public interest, while others believe that the media's role should be limited to reporting the fact and allowing the court to decide the outcome of the case. One of the recent examples of media trial in India is the coverage of the death of actor Sushant Singh Rajput in 2020. The media extensively covered the case and speculated about the cause of his death, even before the police investigation was complete. This led to public outcry and pressure on the justice giving system. The media coverage of the case led to a lot of speculation and controversy theory, which impacted the investigation and the trial. Another example of media trial in India is the coverage of 2008 Mumbai terror attacks. The media coverage of the attacks was so intense that it was criticized for providing real-time information to the terrorists and potentially compromising the rescue operation. The media coverage also focused on the sensational aspects of the case, such as the identities of the attackers and their motives, which may have impacted the investigation and the trial. Now discuss impact of media trial on the justice delivery system. First is pressure on judges. Media activism imposes an indirect pressure on the adjudicating authorities to deliver justice to victims who may interfere with the trial proceeding and may cause prejudice to the accused and the chance of proving his innocence. Second, right to privacy. They invade their privacy, which causes a breach of the right to privacy guaranteed under Article 21 of Indian Constitution. The news is whatever sells the best, but the need to compete for the commercialization and more views has transformed the media today into full-fledged game of viewership. The name of the game is ratings, viewership, eyeballs and commercialization. Last is sensationalism. The recent example of prioritization and extreme coverage of a superstar's son over alleged drug abuse has opposed to covering the death of protesting farmers is one of the main instances where media has shown that it seeks to cover sensational news more than any other. This means whatever catches and grasps the attention of the public, or in other words, sensationalism. Let's understand what do we mean by Kangaroo Court. The phrase Kangaroo Court is used against a judicial system where the judgment against the accused is usually predetermined. Moreover, the system does not work on the standards of the law or justice. In Kangaroo Court, the procedure is only conducted as a formality. Kangaroo courts are known for working against the phrase innocent until proven guilty. The court does not allow to appeal against its judgment. Kangaroo courts were common during the Stalin era in the Soviet Union, famous as the Moscow trial of the Soviet Great Purse. Now we will understand what are the regulation on media in India. Media in India is mostly self-regulated. The existing bodies for regulation of media, such as the Press Council of India, which is a statutory body, and the News Broadcasting Standards Authority, a self-regulatory organization, issued standards which are more in the nature of guidelines. The regulation of print media is done by the Press Council of India. The Press Council of India was established under the PCI Act of 1978 for the purpose of preserving the freedom of press and of maintaining and improving the standards of newspaper and news agencies in India. The function of PCI is helping the newspaper maintain their independence, build a code of conduct for journalists and news agencies, help maintain high standard of public taste and foster responsibility among citizens, and review development likely to restrict flow of news. The regulation of electronic media. Today's news channels are governed by mechanism of self-regulation. One such mechanism has been created by the News Broadcaster Association, the NBA. NBA has devised a code of ethics to regulate television content. The News Broadcasting Standard Authority of the NBA is empowered to warn, admonish, censure, express disapproval and fine the broadcaster a sum up to 1 lakh for violation of the code. Another such organization is the Broadcast Editors Association. The Advertising Standard Council of India has also drawn up guidelines on content of advertisements. These groups govern through agreements and do not have any statutory power. And most important regulation, which is the need of the hour, is social media. Certain standards have been prescribed for the content accessible over the internet under the IT Rules 2011. The Ministry of Electronics and Information Technology has published a fresh draft of amendments to the Information Technology Rules 2021. The government has also come up with the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. However, a regulatory body such as the PCI or the CBFC does not exist. Complaints are addressed to the Internet Service Provider or the host. To conclude this lecture, we should understand the meaning of freedom of speech and expression to understand what is the difference between freedom of expression and media trial. Freedom of expression, incorporated in the India's constitution under its Article 19, Clause 1, Subclause A, grants freedom of speech and expression to its citizen. The freedom of press is a necessary element of the freedom of expression that involves a right to receive and impart information, without which democracy becomes an empty slogan. But the right is not absolute and is subjected to the reasonable restrictions of defamation and contempt of court. Regulation of media and the role of civil society. The media should practice better self-regulation. If the government starts regulating the media, the complete purpose would be defeated. An informed, cultivated and interested civil society can be the best watchdog over the politics and the media. What is the way forward of this lecture? To prevent media trial, it is important for journalists to adhere to ethical standards of reporting and to ensure that their coverage is balanced and unbiased. The legal system can also take steps to prevent undue influence on witnesses and other participants. In conclusion, media trials are an contentious issue in India, and it is important for the media and the legal system to work together to ensure that the accused right to a fair trial is protected, while also ensuring that the public has access to important information about legal cases. Thank you so much.